What purpose, gentlewoman from South Carolina, seek recognition?
Mr. Speaker, pursuant to Clause 2A1 of Rule 9, I rise to give notice of my intent to raise a question of the privileges of the House. The form of the resolution is as follows. House Resolution 713, censuring Representative Ilhan Omar of Minnesota and removing her from the Committee on Education and Workforce and the Committee on the Budget. Whereas Charlie Kirk was a lifelong advocate for freedom of speech, civil political discourse, and the political engagement of youth. Whereas Charlie Kirk was a man of deep faith, a husband, and a father to 2 young children. Whereas on September 10, 2025, Charlie Kirk was assassinated on the campus of Utah Valley University while exercising his First Amendment right to freedom of speech. Whereas on September 11, 2025, one day after the assassination of Charlie Kirk, Representative Ilhan Omar gave an interview on Zateo's town hall with Mehdi Hassan in which she smeared Charlie Kirk and implied he was to blame for his own murder. Whereas on September 12, 2025, 2 days after the assassination of Charlie Kirk, Representative Ilhan Omar reposted a video on X, formerly known as Twitter, which disparaged the character of Charlie Kirk and those mourning his death. Whereas the video Representative Ilhan Omar reposted on X states Charlie Kirk is dead, and before the body got cold, the far right propped his corpse up as a cudgel for their holy war. Whereas the video Representative Ilhan Omar reposted on X further states, don't be fooled. These people don't give a single shit about Charlie Kirk. They are just using his death to further their Christo-fascist agenda. Whereas the video Representative Ilhan Omar reposted on X further states Charlie Kirk was a reprehensible human being. He enacted his political agenda by preying on weak-minded people. He took complex socioeconomic issues and simplified them by pointing fingers at outgroups, demonizing those groups, and sicking his massive following on them. Whereas the video Representative Ilhan Omar reposted on X further states Charlie Kirk was a stochastic terrorist, an adamant transphobe. He denied the genocide happening in Palestine. He believed the subjugation of women, and in his last dying words, he was spewing racist dog whistles. Whereas the video Representative Ilhan Omar reposted on X further states, Charlie Kirk was Dr. Frankenstein, and his monster shot him through the neck. Whereas the video Representative Ilhan Omar reposted on X further blames Charlie Kirk for his own murder. Whereas Clause 1 of Rule 13 of the Rules of the House of Representatives provides a member, delegate, resident commissioner, officer, or employee of the House shall behave at all times in a manner that shall reflect credibility on the House. Whereas Representative Ilhan Omar's actions in the wake of the assassination of Charlie Kirk are reprehensible and affect the dignity and integrity of the proceedings of the House and do not reflect the credibility on the House. Now therefore be it resolved that Representative Ilhan Omar of Minnesota be censured. Representative Ilhan Omar forthwith present herself in the well of the House of Representatives for the pronouncement of censure. Representative Ilhan Omar be censured with the public reading of this resolution by the Speaker, and Representative Ilhan Omar be and is hereby removed from the Committee on Education and Workforce and removed from the Committee on the Budget of the House.
Resolution offered from the floor by a member other than the majority leader or the minority leader as a question of privilege of the House has immediate precedence only at a time designated by the chair within 2 legislative days after the resolution is properly noticed. Pending the designation, the form of the resolution noticed by the gentlewoman from South Carolina will appear in the record at this point. The chair will not at this point determine whether the resolution constitutes a question of privilege. That determination will be made at the time designated for the consideration of the resolution. For what purpose does the gentleman from Texas seek recognition?
Mr. Speaker, pursuant to Clause 2A1 of Rule 9, I rise to give notice of my intention to raise a question of the privileges of the House. The form of the resolution is as follows. A resolution censuring Representative Corey Mills. Whereas Representative Corey Mills has on several occasions conducted himself in a manner that reflects discredit upon this House of Representatives. Whereas on February 19, 2025, Washington, D.C. Metropolitan Police officers were called to resolve a private matter at Representative Corey Mills' residence, where officers were called to the 1300 block of Maryland Avenue Southwest around 1:15 p.m. for a report of an assault. Whereas police reports obtained by NBC4 Washington confirmed that the Washington, D.C. Police Department was investigating Representative Corey Mills for an alleged assault on a 27-year-old woman that took place on February 19, 2025, at the residence of Representative Corey Mills. Whereas the first police report provided to NBC4 Washington by a source and confirmed by a second source familiar with the investigation said that the 27-year-old woman accused her significant other for over a year of having grabbed her, shoved her, and pushed her out of the door, and also said that the woman involved showed the officer, quote, bruises on her arm which appeared fresh, end quote. Whereas NBC4 Washington also reported that the Metropolitan Police Department identified Representative Corey Mills as the significant other of the alleged victim of assault, who was not the wife of Representative Corey Mills, and that the alleged victim, quote, let officers hear subject one, now identified by MPD as Mr. Mills, instruct her to lie about the origin of her bruises. Eventually, subject one, who we now know is Representative Corey Mills, made contact with police and admitted the situation escalated from verbal to physical, but it was severe enough to create bruising, end quote. Whereas on February 21st, 2025, the Washington Post also confirmed two D.C. police officials said that the alleged victim of the assault initially told 911 and police that she had been assaulted, and that officers said she also had what seemed to be visible injuries, and that while a supervisor initially classified the offense internally as family disturbance, police commanders later learned of the incident, reviewed the reports and body camera footage, and reclassified the case as domestic violence assault. Whereas on February 21, 2025, NBC4 Washington also reported that the Metropolitan Police Department determined that the probable cause to arrest Representative Corey Mills for misdemeanor assault existed and sent an arrest warrant for Representative Corey Mills to the United States Attorney's Office for the District of Columbia. However, then acting United States Attorney for the District of Columbia, Ed Martin, refused to sign the arrest warrant for Representative Corey Mills and instead returned the case to the police department for further investigation. Whereas on July 14, 2025, a different former romantic partner of Representative Corey Mills, who was apparently in a relationship with Representative Mills from November 2021 to February 2025, reported to the authorities in Florida that Representative Mills threatened to release nude images and other intimate videos of her and threatened to harm her future romantic partners in retaliation for her decision to end a relationship with Representative Mills after seeing the public reports described above concerning the alleged February 2025 physical assault. Whereas in August 2024, the Office of Congressional Conduct adopted and transmitted to the Committee on Ethics of the House of Representatives a report indicating that there was substantial reason to believe that Representative Corey Mills may have omitted or misrepresented required information in his financial disclosure statements, accepted excessive contributions to his campaign committee in the form of personal loans and contributions that may not have derived from Representative Corey Mills' personal funds, entered into, held, or enjoyed contracts with federal agencies while he was a member of Congress, and may have accepted through his campaign committee in-kind contributions or other contributions not lawfully made. Whereas individuals who served Representative Corey Mills have called into question the veracity of the account of events which formed the basis of a recommendation that Representative Corey Mills receive an award of Bronze Star bestowed in 2021 for his service under enemy fire in Iraq in 2003. Whereas in August 2024, Representative Mills provided the Daytona Beach News with documents purporting to prove that he earned a Bronze Star for heroism, including a Department of the Army Form 638, recommending Representative Mills for a Bronze Star, and which includes a signature from then Army Brigade Commander Arnold N. Gordon Bray. However, retired Brigadier General Bray told the Daytona Beach News Journal in August of 2024 that he did not sign a Bronze Star recommendation for Congressman Corey Mills. Whereas 5 people who served with Representative Corey Mills, including 2 men who were reported as having been personally saved by Representative Mills at great risk to his own life as a basis for his recommendation for his Bronze Star in the Department of the Army Form 638, those 2 men disputed that Representative Corey Mills was involved in their rescue or provided life-saving care. Whereas 1 private first class cited as having been involved in one of the listed achievements on Representative Corey Mills' Army Form 638, recommending him for a Bronze Star, denied that Representative Corey Mills provided him any aid and also denied that his injuries were life-threatening. Whereas 1 sergeant cited as having been involved in one of the listed achievements on Representative Corey Mills' Army Form 638, recommending him for a Bronze Star, called the account a, quote, fabrication, and claimed that he, quote, was not in any claims that Corey Mills makes, not involved in any claims that Corey Mills makes about me. I'll restate that, Mr. Speaker. Whereas 1 sergeant cited as having been involved in one of the listed achievements on Representative Corey Mills' Army Form 638, recommending him for a Bronze Star, called the account a, quote, fabrication, and claimed that he, quote, was not involved in any claims that Corey Mills makes about me, end quote. And whereas despite the numerous available contradictions of the accounts forming the basis of the recommendation for his Bronze Star, Representative Corey Mills described the legitimate factual disputes raised by individuals he purportedly served with and rescued as, quote, slander and defamation in a statement to the Daytona Beach News Journal. Now, therefore, be it resolved that 1, Representative Corey Mills be censured, 2, Representative Corey Mills forthwith present himself in the well of the House of Representatives for the pronouncement of the censure, and 3, Representative Corey Mills be censured with a public reading of this resolution by the Speaker. I yield back.
Gentleman yields under Rule 9 a resolution offered from the floor by a member other than the majority leader or the minority leader as a question of the privileges of the House has immediate precedence only at a time designated by the chair within 2 legislative days after the resolution is properly noticed. Pending that designation, the form of the resolution noticed by the gentleman from Texas will appear in the record at this point. The chair will not, at this point, determine whether the resolution constitutes a question of privilege. That determination will be made at the time designated for consideration of the resolution. For what purpose does the gentleman from Kentucky seek recognition?
Mr. Speaker, pursuant to House Resolution 707, I call up the bill H.R. 4922, the D.C. Crimes Act.
The clerk will report the title of the bill.
H.R. 4922, a bill to limit youth offender status in the District of Columbia to individuals 18 years of age or younger, to direct the Attorney General of the District of Columbia to establish and operate a publicly accessible website containing updated statistics on juvenile crime in the District of Columbia, to amend the District of Columbia Home Rule Act to prohibit the Council of the District of Columbia from enacting changes to existing criminal liability sentences and for other purposes.
Pursuant to House Resolution 707, the amendment in the nature of a substitute consisting of the text of Rules Committee Print 119-10 is adopted and the bill as amended is considered read. The bill as amended shall be debatable for 1 hour, equally divided and controlled by the chair and ranking minority member of the Committee on Oversight and Government Reform or their respective designees. The gentleman from Kentucky, Mr. Comer, and the gentleman from California, Mr. Garcia, each will control 30 minutes. The chair recognizes the gentleman from Kentucky.
Mr. Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous material on the measure under consideration.
Without objection.
Mr. Speaker, I yield myself such time as I may consume.
Gentleman is recognized.
Thank you, Mr. Speaker. I support H.R. 4922, a bill providing common sense reforms to the District of Columbia Criminal Code. It is clear to members of the committee and the public that D.C.'s soft on crime policies have failed to keep D.C. residents and visitors safe. The D.C. Crimes Act overturns targeted portions of the D.C. Council's Youth Rehabilitation Act by amending the definition of a youth offender from a person under the age of 25 to under the age of 18. Let me emphasize Washington, D.C.'s current law. Currently, D.C. Code allows a criminal under the age of 25 to be given the same leniency that is afforded to minors. This bill requires that we treat adult criminals as adults, like the rest of the country. It also removes judicial discretion to sentence youth offenders under the minimum sentencing structures in place. Our capital cannot continue to let criminals freely roam the streets and expect this crime crisis to end. As juvenile crime soars in the district, the bill also requires the D.C. Attorney General to create a publicly available website that better tracks juvenile crime data. This data will inform Congress, the district's elected officials, the Metropolitan Police Department, the public, and others of the severity of juvenile crimes in this city. Citizens of D.C. and visitors to our nation's capital deserve to feel safe. I want to thank Representative Byron Donalds from Florida for leading this effort again this Congress, and I encourage my colleagues to join me in supporting this legislation. I reserve the balance of my time.
Gentleman reserves. Now recognize the gentleman from California.
Thank you, Mr. Speaker. Now, today we are considering the first of 4 bills which represent a serious violation of the rights of Washington, D.C. and the democratic process. Now, we know that D.C. has more residents than 2 states. D.C. taxpayers pay federal taxes more per capita than any state, and D.C. as a whole contributes more federal taxes than 12 states. There are over 700,000 active residents here who deserve a voice. Now, D.C.'s government is accountable to the people who live here, and local leaders should and are empowered to solve local problems without Congress interfering. Now, I've said this many times. If Donald Trump wants to run D.C., he should resign as president and run for mayor. And if my colleagues here want to legislate for D.C., there are plenty of opportunities to run for the D.C. City Council. Now, I was the mayor of my city for 8 years before I came to Congress, and I love local government. A lot can get done and accomplished. But let's not sit here in Congress and pretend to be a super city council imposing our pet policies on residents who reject this agenda. Now, the bill before us right now is called the D.C. Crimes Act, or the so-called D.C. Crimes Act. This bill will impose longer sentences on young people who commit crimes. But how does it do this? It eliminates the ability of judges to make the best sentencing decisions for young adults. It will lead to worse outcomes, more reoffenders, and less safety. Now, let's be clear. This bill is not about making anyone safer or D.C. safer. It's about stripping decision-making away from the people and the judges of D.C. and instead handing the power of judges over to politicians in this room who don't live here, who don't vote here, and certainly don't answer to D.C. residents. This bill amends D.C.'s Youth Rehabilitation Act, or the YRA as it's known. Now, the YRA is not radical. It has been in place since 1985, and it actually mirrors laws in states like Florida and Michigan. Its purpose is simple: to give judges discretion in sentencing young adults. Now, judges can punish some young people when appropriate in ways that reduce their risk of reoffending. But this bill would rip away discretion. It eliminates a judge's ability to waive mandatory minimums, even when the facts show a one-size-fits-all sentence makes no sense. Judges, not politicians, should decide sentences. Now, individuals whose convictions are set aside under the YRA are less likely to reoffend. That means the law works and it keeps communities safer. Now, we also know that in nearly 80% of cases, judges impose a mandatory minimum sentence anyway. These waivers are rarely granted and only when a judge determines it is appropriate. This bill is an undemocratic attack on D.C., its residents, and is also just bad policy. Now, Republicans in the majority claim D.C.'s policies are too soft. But we know that the sponsor of this bill is also from Florida, which has allowed judges to waive mandatory minimums for decades. Florida even caps youth offender sentences at 6 years, something D.C., by the way, has never done. Let's be clear, and we can all agree, that violent crime has no place in our communities. People are rightly concerned about crime in D.C. and back home in their communities, and Democrats, of course, want safe streets. But we believe in investing in solutions that actually make people safer, not political stunts or short-term gimmicks or cheap, tough talk. And we know what works: supporting local police departments, investing in community-based partnerships, and creating economic opportunity to drive down shootings, homicides, and burglaries. Now, getting guns out of the hands of violent criminals keeps us all safer. But instead of doing that work, Republicans are wasting time attacking the district while ignoring the crisis in their own backyards. Now, former President Trump is doing nothing to address violent crime in states with some of the highest crime rates in the country. In fact, his administration has made things worse. Trump has opposed efforts to expand criminal background checks. He has blocked attempts to reduce ghost guns and machine gun conversion devices. His Department of Justice has gutted the number of inspectors who stop businesses from selling guns to criminals, cutting that workforce down by 2/3. And on top of that, Trump illegally froze or canceled $3.8 billion in DOJ grant programs, including COPS grants for our police departments that, of course, help communities hire and train police officers. I urge my colleagues to reject this misguided power grab. With that, I reserve my time.
Gentlemen, reserve. Members are reminded to refrain from engaging in personalities toward the president. Gentleman from Kentucky is recognized.
Thank you, Mr. Speaker. I yield 3 minutes to the sponsor of the bill, the gentleman from Florida, Mr. Donalds.
Gentleman is recognized.
Thank you, Mr. Speaker. I rise today in strong support of my bill, H.R. 4922, the D.C. Crimes Act. Now, in reference to what the gentleman was just talking about, Article 1, Section 8, Clause 17 of the United States Constitution is quite clear. It grants Congress the power to exercise exclusive jurisdiction over the federal district, which all Americans know now is Washington, D.C., and it is the nation's capital. That is in the Constitution that was ratified by the several states. Congress does have the constitutional authority to regulate activities within the federal district. So when it is said that somehow Congress is now eroding local control, that is simply not true. Any local powers by the D.C. City Council have been granted to the D.C. City Council by Congress. And Congress is the seat of authority when it comes to the federal enclave. It was also talked about Florida's laws. Well, let's be very clear. Florida has established itself as a beacon of law and order and making sure that our citizens are safe throughout all of our jurisdictions. So if there are some abilities for some measures of flexibility, Florida has proven beyond a shadow of a doubt that it knows how to keep its people safe. Very different with respect to the D.C. City Council and with respect to crime, escalated crime here in the nation's capital. Our great nation's capital has been plagued by violence, destruction, disorder for far too long, and decades of weak pro-crime leadership has turned this once great city into a dystopia. I would remind my colleagues on the other side of the aisle that some of their colleagues have been victimized by the crime here in Washington, D.C. Rather than prioritizing the safety of law-abiding and protecting the lives of innocent residents and visitors, district officials have actively facilitated dysfunction and chaos through their progressive soft-on-crime policies. Instead of addressing the clear epidemic of youth crime in the city, the D.C. City Council increased the age of youth offenders to individuals 24 years old and younger, meaning fully grown legal adults in the District of Columbia can receive sentences meant for children. This is simply insane. And that is why I introduced the DC Crimes Act, which lowers the definition of youth from under the age of 25 to under the age of 18, removes the ability of judges to sentence youth offenders below mandatory minimum guidelines, and requires the DC Attorney General to establish a public website containing much needed statistics on juvenile crime in DC. The Trump administration's efforts have shown that lawlessness is a choice. And it is time for Congress to step up, adhere to our constitutional duty, and firmly address crime in the nation's capital. For the citizens of DC, I would say, we wish your council did this the right way, but they did not, and we will act. I yield back the balance of my time.
Reserve.
Gentleman from Kentucky reserves. Recognize the gentleman from California.
Thank you, Mr. Speaker. I yield 7 minutes to the gentlewoman from the District of Columbia, Representative Norton.
The gentlewoman is recognized.
I thank the gentleman for yielding. I strongly oppose this undemocratic and paternalistic bill, which amends D.C. law. The over 700,000 D.C. residents, the majority of whom are black and brown, are capable and worthy of governing themselves. I ask unanimous consent to enter into the record letters opposing this bill from D.C. Mayor Miriam Bowser and the entire D.C. Council and D.C. Attorney General Brian Schwab.
Without objection.
The local legislature, the council, has 13 members. If D.C. residents do not like how members vote, residents can vote them out of office or pass a ballot measure. That is called democracy. Congress has 535 voting members. None are elected by D.C. residents. If D.C. residents do not like how members vote on local D.C. matters, residents cannot vote them out of office or pass a ballot measure. That is the antithesis of democracy. The substance of this bill should be irrelevant since there is never justification for Congress to legislate on local D.C. matters. Nevertheless, I will discuss it. Republicans claim D.C.'s Youth Rehabilitation Act treats adults as juveniles. They are wrong. They either do not understand the act or are misleading the public about it intentionally. The act's sentencing and set-aside provisions apply only in adult court, not juvenile court. Let me repeat. The provisions apply in adult court, not juvenile court. A judge may, but is not required, to sentence a purpose under the act, and certain crimes are ineligible under the act. D.C. is not the only jurisdiction with a so-called young adult offender law. Alabama, Florida, Michigan, New York, South Carolina, and Vermont have such laws. The sponsor of this bill is from one of those states. D.C. residents have all the obligations of American citizenship, including paying federal taxes, serving on juries, and registering with the Selective Service. Yet Congress denies them full local self-government and voting representation in Congress. The only solution to this undemocratic treatment is to grant D.C. statehood. I ask unanimous consent to enter into the record a letter explaining why D.C. statehood is constitutional from leading constitutional scholars, including Larry Tribe.
Without objection.
The D.C. statehood bill, H.R. 51, the Washington, D.C. Admission Act, grants D.C. residents full local self-government and voting representation in Congress. H.R. 51 reduces the size of the federal district from 68 square miles to 2 square miles, consisting of the White House, the Capitol, the Supreme Court, and the National Mall, and remaining under the control of Congress. The new state consists of the residential and commercial areas of D.C. The new state has a larger population than 2 states, pays more federal taxes per capita than any state, and pays more local federal taxes than 21 states. I urge members to vote no on the D.C. Crimes Act, keep their hands off D.C., and free D.C. I yield back.
Gentleman from California reserves. Recognize the gentleman from Kentucky.
I yield 2 minutes to the gentleman from Georgia, Mr. Carter.
Without objection.
I thank the gentleman
Gentleman's
for yielding. Mr. Speaker, I rise today in strong support of the D.C. Crimes Act, legislation that builds on the extraordinary progress we've seen under President Trump's leadership to restore law and order in Washington, D.C. Thanks to President Trump and his administration, we are finally seeing real results in this city. Crime is down, homicides are down, carjackings are down, and most importantly, people feel safer in their nation's capital. President Trump has handed us the blueprint to restore safety in America's cities. Families are safely going out to restaurants, businesses are seeing life return to their neighborhoods, and tourists feel secure knowing law enforcement officers are empowered to do their job and enforce the law. The D.C. Crimes Act ensures that the gains we've made are not rolled back by more democratic pro-crime policies. Republicans are the party of safe cities. We are the party that stands with our police and responds to our communities who demand law and order. This bill sends a simple message. Criminals will be held accountable, victims will be protected, and Washington, D.C. will remain on the path to becoming the safe, thriving capital our nation deserves. I urge my colleagues to support the D.C. Crimes Act and keep our capital safe, strong, and beautiful. Thank you, Mr. Speaker, and I yield back.
From Kentucky reserves, the gentleman from California is recognized.
Thank you, Mr. Speaker. I'd like to yield 2 minutes to the gentlewoman from Texas, Representative Crockett.
Thank you, Mr. Speaker.
Gentlewoman is recognized.
Thank you, Mr. Speaker. As I sat and listened to the beginning of this debate, my heart simply broke. And many people know me for being able to do alliterations, and all I could think about was amnesia allows adolescent accountability avoidance agility from across the aisle. So work with me for a second. Imagine being a young man born to Jamaican and Panamanian parents who messed up not once but twice. Imagine standing in front of a judge with your whole future hanging in the balance, and instead of prison, you are given a promise of mercy. Your record gets wiped clean. You get a second chance at life. Now imagine taking that promise and turning it into promotion. You go to college, you get a job, and even become a member of Congress. That's what redemption looks like. That's what America is supposed to be about. And that is exactly the story of the next wannabe governor from Florida. As a young man, he went through pretrial diversion for misdemeanor marijuana possession. As an adult, yet younger than 24, he was charged with and ultimately placed on probation for felony bribery charges, which ultimately were 2 expunged. He was given a 3rd chance, and now he's the face of a bill that would not afford young people in Washington, D.C. the same opportunities afforded to him. Let me be real. If he had grown up under Donald Trump's America or under the very D.C. crime bill he's pushing today, he wouldn't be standing here as a member of Congress. He'd still be living with the weight of those charges. So let's call this what it is, opportunities for me, but not for thee. He climbed the ladder of redemption, and now he's yanking it right up from the D.C. youth. See, most of us were taught to lift as you climb, but clearly some have forgotten to lift as they climb, and now they are committed to telling the next generation to pull themselves up by their bootstraps. I will not sit quiet while a man who was saved by grace turns around and tries to snatch grace away from others. If we're going to be real about crime, about communities,
time
about...
has expired.
I'd like to yield for an additional minute, please.
Gentlewoman is recognized.
About second chances and even 3rd chances, then it needs to start with us looking in the mirror and remembering that even the author of this bill has a story too before he tries to lecture D.C. on safety. And it would be complete hypocrisy to have, hypothetically, someone convicted of 34 felonies to lecture DC on what to do with youthful offenders who have been scientifically shown not to have fully developed brains under the age of 25, especially if said multi-count convicted felon was in his 70s when he was convicted. What would be his excuse? Because his brain would be fully developed, and with that, I will yield back.
Gentleman reserves. Recognize the gentleman from Kentucky.
Mr. Speaker, I yield 2 minutes to the distinguished gentleman from Tennessee, Mr. Burchett.
Gentleman is recognized.
Thank you, and thank you, Mr. Chairman. I rise today in disbelief over the fact that in our own nation's capital, prosecutors are allowed to prosecute criminals as old as 25 years old as minors. While President Trump has restored law and order to the district, I am not surprised that D.C.'s local government continues to protect the criminals and ignore victims. The D.C. Crimes Act puts an end to this madness and ensures safety and security across D.C. At 18 years old, you're given adult responsibilities like being able to vote or sign up for the military. At 18 years, you become responsible for your choices and your decisions and should be treated as such. At 21 years old, you're able to legally consume alcohol, and at 25 years old, you can become a member of Congress. This is why the D.C. Crimes Act is essential to ensuring long-term safety and security of our nation's capital so that violent offenders are not just handed any more get-out-of-jail-free cards. The bill also orders judges to stop sentencing youth offenders below the minimum sentencing guidelines. It's time to bring justice in America. It's time for fair punishment for the people who interfere with people's daily lives, specifically those with prior convictions. The revolving door of justice ends today, and I cannot thank Representative Donalds enough for his work on this vital legislation. It's time to push back against soft-on-crime judges and DAs. We are a nation of laws, Mr. Speaker, and Washington, D.C. should be a model for justice across our great nation. In no way, shape, form, or fashion should we be charging adults as minors and allowing them to return to commit similar or more violent crimes. The citizens, tourists, business people, and every other member of this city deserve safety and security. I urge my colleagues to support this bill, which will ensure just that. We will restore D.C. to become the shining city on the hill that our founders envisioned it to be. Thank you again to my dear friend, Congressman Donalds, and I urge my colleagues to vote yes on this bill. Thank you, Mr. I yield back.
Gentleman from Kentucky reserves. Gentleman from California is recognized.
Thank you, Mr. Speaker. I reserve my time.
Gentleman reserves. Gentleman from Kentucky is recognized.
Mr. Speaker, I yield 3 minutes to the distinguished lady from Colorado, Ms. Boebert.
The lady is recognized.
Thank you, Mr. Speaker, and thank you to Chairman Comer and to the Free State of Florida's next governor, Byron Donalds. I rise in support of H.R. 4922, the D.C. Crimes Act, which is sponsored by Congressman Donalds. This critical legislation is a direct response to the failed pro-crime policies that have turned our nation's capital into a war zone. Under failing leftist policies, Washington, D.C. has seen an epidemic of violence, carjackings surging 300%, homicide ravaging communities, and young thugs, some as old as 24, treated as juveniles, slapped with lenient sentences below mandatory minimums. It endangers young families and small businesses struggling in this crime-ridden city. Innocent residents live in fear while criminals roam free, mocking the rule of law. H.R. 4922 cuts through this madness. It ensures adults face adult consequences. It repeals judges' abilities to dodge mandatory minimums for youth crimes. And crucially, it blocks the D.C. Council from gutting sentencing laws, reclaiming Congress's congressional constitutional oversight over this federal district, as it should be. As President Trump declared in his March 2025 executive order, if D.C. won't act, we must, restoring order, beauty, and safety to our capital. This bill isn't about politics. It's about protecting lives. Republicans are delivering real reform, tougher accountability, transparent juvenile crime data via public website, and a safer D.C. for all. I urge my colleagues to join us and pass H.R. 4922 now to make America and this district safe again. Thank you, Mr. Speaker. I yield.
Reserve.
Gentleman from Kentucky reserves.
Reserve the balance of my time.
Gentleman reserves.
Mr. Speaker, I yield 2 minutes to the distinguished lady from Wyoming, Ms. Hegerman.
Gentlewoman is recognized.
Thank you, Mr. Chairman. I rise in support of H.R. 4922 so that we may redefine what is considered to be a youth offender from 24 years to 18 years and repeal the D.C. criminal court provision that allows youthful offenders to receive sentences less than the mandatory minimum required by law. There is no question that there has been a crime epidemic across the District of Columbia, and the citizens of this great city deserve better. President Trump recognized this fact and has exercised his authority to restore safety. It is now time for Congress to build on his good work. H.R. 4922 is designed to begin to address many of the problems that stem from the D.C. courts and their refusal to hold criminals accountable. We need to start with recognizing that 19 to 24-year-olds shouldn't be treated as youthful offenders. Local news has recently reported that the number of juveniles arrested in Washington, D.C. has increased every year since 2020, and that 60% of carjackings in the district in 2025 so far are for those over 20 years old. Knowing that the District of Columbia currently classifies anyone 24 years or younger as a youth offender, it is fair to ask, how many of these so-called youthful offenders running rampant, terrorizing the hardworking people of Washington, D.C., are actually adults and should be tried as such? This situation is untenable and should not be tolerated in a civilized society. I am therefore pleased to support the solutions presented by H.R. 4922, including the establishment of a website on District of Columbia juvenile crime statistics. Passage of this bill will go a long way to correcting the broken, soft-on-crime policies here in Washington, D.C. that coddle criminals and place at risk the good, honest, and hardworking people that call the district home. I want to thank Representative Donalds for sponsoring this important legislation and applaud Chairman Comer for his steadfast leadership on this critically important issue. I urge all my colleagues to join me in supporting H.R. 4922, and I yield back.
Reserve.
Gentleman from Kentucky reserve.
Okay, no more speakers.
California is recognized.
Thank you. No more speakers and prepare to close.
Gentleman from California is recognized.
I oppose passage of this bill, and I want to yield back.
And yields back. Gentleman from Kentucky.
Thank you, Mr. Speaker. I urge my colleagues to support this common sense legislation to ensure that citizens of Washington, D.C. and the many visitors to our nation's capital deserve to feel safe. I yield back the balance of my time.
All time for debate has expired. Pursuant to House Resolution 707, the previous question is ordered on the bill as amended. The question is on the engrossment and third reading of the bill. Those in favor say aye. Those opposed say no. The ayes have it. Third reading.
A bill to limit youth offender status in the District of Columbia to individuals 18 years of age or younger, to direct the Attorney General of the District of Columbia to establish and operate a publicly accessible website containing updated statistics on juvenile crime in the District of Columbia, to amend the District of Columbia Home Rule Act to prohibit the Council of the District of Columbia from enacting changes to existing criminal liability sentences and for other purposes.
Question is on passage of the bill. Those in favor say yea. Those opposed, no. Yeas have it. The bill is passed, and without objection, the motion to reconsider is laid on the table.
Request a recorded vote, please.
For what purpose does the gentleman from California seek recognition?
Request the yeas and nays.
The yeas and nays are requested. Those favoring a vote for yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered pursuant to Clause 8 of Rule 20. Further proceedings on the question will be postponed. For what purpose does the gentleman from Kentucky, Mr. Comer, seek recognition?
Mr. Speaker, pursuant to House Resolution 707, I call up the bill H.R. 5140 to lower the age at which a minor can be tried as an adult for certain criminal offenses in the District of Columbia to 14 years of age and ask for its immediate consideration.
The clerk will report the title of the bill.
H.R. 5140, a bill to lower the age at which a minor may be tried as an adult for certain criminal offenses in the District of Columbia to 14 years of age.
Pursuant to House Resolution 707, the amendment in the nature of a substitute consisting of the text of House Rules Committee Print 119-12 is adopted, and the bill as amended is considered read. The bill as amended shall be debatable for 1 hour, equally divided and controlled by the chair and ranking member of the Committee on Oversight and Government Reform or their respective designees. The gentleman from Kentucky, Mr. Comer, and the gentleman from California, Mr. Garcia, each will control 30 minutes. The chair now recognizes the gentleman from Kentucky, Mr. Comer.
Mr. Speaker, I ask you to consider that all members have 5 legislative days to revise and extend their remarks and include extraneous material on the measure under consideration.
Without objection.
Mr. Chair, I yield myself such time as I may consume.
So recognized.
Thank you, Mr. Speaker. I support H.R. 5140 to lower the age at which a minor may be tried as an adult for certain criminal offenses in the District of Columbia to 14 years of age. The District of Columbia has seen a staggering increase in juvenile crime since the pandemic. According to Metro Police Department, 51.8% of all robbery arrests in 2024 were juveniles, and 53% of all carjacking arrests in 2025, as of August, were juveniles. Congress must respond to these violent crimes being committed by juvenile perpetrators. Currently, minors 16 years old and older are eligible to have their case moved up to criminal court and to be tried as an adult in D.C. This bill lowers that age to 14 years old, making 14 and 15-year-olds who commit violent crimes eligible to be charged as adults. Violent crime refers to murder, first-degree sexual abuse, burglary in the first degree, and robbery while armed, for example. When juveniles commit crimes of this magnitude, they deserve sentencing that reflects the seriousness of the crimes they committed. I want to thank Representative Brandon Gill for leading this legislation and urge all my colleagues to support this bill. I reserve the balance of my time.
Gentleman from Kentucky reserves. Gentleman from California is recognized.
I yield myself time as I consume.
So recognized.
Well, thank you, Mr. Speaker. Once again, we're back with a second bill to undermine Washington, D.C. with an undemocratic and misguided policy. Now, Republicans in Congress are once more acting again as a city council for D.C., overriding the choices of local residents and their elected officials while ignoring the real issues the rest of the country faces. Now, nearly 700,000 tax-paying Americans in D.C. deserve the same right to self-governance as every other community, including control over criminal laws. Now, Democrats on the Oversight Committee strongly oppose this bill, which would allow children as young as 14 years old to be charged as adults. Now, let's be clear. This bill is not about safety. It's about stripping away jurisdiction and sending more children into the adult prison system. Now, this bill lowers the age at which children can be tried as adults in D.C. from 16 to 14 years old for certain crimes. If you commit a crime, you should be held accountable, and we all can agree on this. But a 14-year-old is not an adult. They are a middle schooler. Their brains are still developing. Treating them as adults is shameful. We can all agree that children should be treated differently by our courts. That matters when it comes to accountability and rehabilitation. And here's what the research shows. Youth charged as adults are more likely to reoffend than youth that go through the juvenile courts. And that's not speculation, it's what decades of data show. Now, the CDC reviewed the evidence and found that sending kids to adult prisons increases violence, does not reduce it. And the National Research Council concluded that keeping punishment in line with age is the best way to prevent future offending. Now, every shred of research says the same thing. Putting kids in adult prison makes us less safe, not more safe. House Democrats know that violent crime, of course, has no place in our communities. And people are right to be concerned about crime. And Democrats are taking it seriously. So if the goal is safer communities, this bill moves us in the wrong direction. Let's also talk about who this bill impacts. More than 93% of youth arrests in D.C. in the first half of this year were black youth. D.C. already has the highest youth incarceration rate in the country, more than 3 times the national average. This bill would take those discrepancies and make them worse, funneling even more children to the adult system. Now, the bottom line is simple. The legislation in front of us does not make us safer, does not make D.C. safer. It makes D.C. less safe. It will deepen racial disparities, and it will push more kids into adult prisons when they're more likely to come out worse than they were, not better. If we care about public safety, the last place we should be doing is putting 14-year-olds in adult prison. Instead of taking power away from D.C. residents and their elected officials, Congress should be focused on real national priorities like addressing gun violence that threatens communities, it threatens schools, it threatens our cities every single day. And finally, the rules in front of us have been created through incredible work of the community, through hearings, through meetings, through public testimony. Let's not all throw that out now. This bill is not about making D.C. safer. I urge my colleagues to vote no, and I reserve my time.
The gentleman from California reserves. The gentleman from Kentucky is now recognized.
Mr. Speaker, I yield 4 minutes to the sponsor of the bill, Mr. Gill from Texas.
The gentleman is recognized.
Thank you, Mr. Speaker. Mr. Speaker, Washington, D.C. is the capital of the United States, and it should reflect the glory and the beauty and the grandeur of the most powerful civilization that has ever existed on the face of the earth. Mr. Speaker, unfortunately, that's not the case under Democrat rule. Under Democrat rule, especially in our nation's capital, we are forced to live under the cloud of anarcho-tyranny where criminals roam free and law-abiding families live in fear. Mr. Speaker, under President Trump's leadership, Republicans are restoring law and order to cities that have been virtually abandoned by the left. That's why I introduced the D.C. Juvenile Sentencing Reform Act to make sure that violent criminals are treated like violent criminals no matter what their age. Mr. Speaker, in 2021, Uber Eats driver Mohammed Anwar was murdered in D.C. during a carjacking by 2 teenage girls. One of the criminals was 15 years old. She was convicted of felony murder, and she was given a maximum sentence under D.C. law, and she'll be free when she turns 21 years old. That's 6 years for murder, for taking a father away from his family. This bill ensures that that travesty of justice never happens again. Mr. Speaker, the reality of crime in D.C. is bleak. D.C.'s homicide rate in 2024 was 27.3 per 100,000. That is the 4th highest in our nation. In the first 6 months of 2025 alone, juveniles in D.C. were arrested 900 times, and many of those arrests were for repeat violent offenders. Around 200 juveniles arrested for violent crimes in 2024 had prior violent crime arrests. Mr. Speaker, this isn't rehabilitation. This is a revolving door of crime that the left has created in this city. Meanwhile, the D.C. City Council passed reforms to weaken policing and reduce penalties for carjacking and robbery. They're choosing, as a matter of policy, criminals over innocent Americans. Mr. Speaker, we hear from the other side of the aisle that locking up criminals by some weird, bizarre logic increases crime. The reality, which we all know because it is self-evident, is that when a criminal is in jail, they are by definition not committing crimes on our streets and not terrorizing innocent Americans. We're told that if we care about public safety, we shouldn't put criminals in prison. Mr. Speaker, this is insane, and they know it, and the American people know it. If we want to live in a law-abiding society, we have to get these violent, ruthless offenders off of our streets. That's what Republicans are doing, and that's what Democrats on the other side of the aisle are fighting right now. Mr. Speaker, this legislation lowers the age for transfer to adult court from 16 to 14 for the most heinous crimes. We're talking about murder, first-degree sexual assault, armed robbery, and burglary. It expands the cases that can be tried by the U.S. Attorney's Office, ensuring that woke, weird prosecutors like D.C. Attorney General Brian Schwab can't let violent offenders slip through the cracks. It sends a simple message: Democrats may tolerate crime, but Republicans do not. Mr. Speaker, every American should be able to walk down our streets without fear of being murdered or raped or having their car broken into. Every parent should be able to put their child to bed without wondering if their home is going to be broken into.
I yield another minute to the gentleman from Texas.
This bill restores order and common sense to the laws of our nation's capital. The American people, every visitor in D.C. as well, deserves nothing less. And with that, I yield back the remainder of my time.
The gentleman from Texas yields. The gentleman from Kentucky reserves. The gentleman from California is recognized.
Thank you, Mr. Speaker. I yield 7 minutes to the gentleman from the District of Columbia, Representative Norton.
The gentleman is recognized. Gentlewoman is recognized.
I thank the gentleman for yielding. I strongly oppose this undemocratic and paternalistic bill, which amends D.C. law. The over 700,000 D.C. residents, the majority of whom are black and brown, are capable and worthy of governing themselves. I ask unanimous consent to enter into the record letters opposing this bill from D.C. Mayor Muriel Bowser, the entire D.C. Council, and D.C. Attorney General Brian Schwab.
Without objection.
While Congress has authority to legislate on local D.C. matters, it does not have a duty to do so. It is a choice. In Federalist 43, James Madison said of D.C. residents, a municipal legislature for local purposes derived from their own suffrages will, of course, be allowed them. Since 1802, Congress has established various types of local government for D.C. In 1953, the Supreme Court held there is no constitutional barrier to the delegation by Congress to the District of Columbia of full legislative power. The local D.C. legislature, the council, has 13 members. If D.C. residents do not like how members vote, residents can vote them out of office or pass a ballot measure. That is called democracy. Congress has 535 voting members. None are elected by D.C. residents. If D.C. residents do not like how members vote on local D.C. matters, residents cannot vote them out of office or pass a ballot measure. That is the antithesis of democracy. The substance of this bill is irrelevant since there is never justification for Congress to legislate on local D.C. matters. Nevertheless, I will discuss it. I strongly oppose charging 14-year-olds as adults. However, whether to amend D.C. law to reduce or increase minimum age, a minor can be charged as an adult should be a decision for D.C. alone. In a series of cases involving 2005, the Supreme Court has recognized that children are constitutionally different from adults for purposes of sentencing. In these cases, the court noted that childhood is marked by rashness, proclivity for risk, and inability to assess consequences. The court said its decisions rested not only on common sense, but on what any parent knows, but on science and social science as well. This bill is not only cruel, but counterproductive too. Most incarcerated people return home. The evidence shows that a minor charged as an adult is more likely to reoffend and be violent after release from than a minor charged as a juvenile. DC residents have all the obligations of American citizenship, including paying federal taxes, serving on juries, and registering with the Selective Service. Yet Congress denies them full local self-government and voting representation in Congress. The only solution to this undemocratic treatment is to grant DC statehood. I ask unanimous consent to enter into the record a letter explaining why DC statehood bill is constitutional from leading constitutional scholars, including Larry Tribe.
Without objection.
The DC statehood bill, H.R. 51, the Washington, D.C. Admission Act, grants D.C. residents full local self-government and voting representation in Congress. H.R. 51 reduces the size of the federal district from 68 square miles to 2 square miles, consisting of the White House, the Capitol, the Supreme Court, the National Mall, and remaining under the control of Congress. The new state consists of the residential and commercial areas of D.C. The new state has a larger population than 2 states, pays more federal taxes per capita than any state, and pays more total federal taxes than 21 states. I urge members to vote no on H.R. 5140. Keep their hands off D.C. and free D.C. I yield back.
The gentlewoman yields. The gentleman from California reserves. The gentleman from Kentucky is recognized.
Thank you, Mr. Speaker. What we've heard today, we've debated these bills in a sincere effort to work with the President of the United States to lower crime in D.C. We've heard nothing from the Democrats other than there's no crime problem in D.C. And then a solution is to make Washington, D.C. a state. We're serious about lowering crime. We applaud the efforts of the President of the United States. We will continue to work with him to make our capital city as safe as possible. And I appreciate Brandon Gill, the sponsor of the bill, and Byron Donald, the sponsor of the last bill. Mr. Speaker, I have no further speakers and prepared to close.
The gentleman reserves. The gentleman from California is now recognized.
Thank you, Mr. Speaker. I'd like to yield 5 minutes to the gentlewoman from Massachusetts, Representative Presley.
The gentlewoman is recognized.
Thank you, Ranking Member Garcia. Mr. Speaker, I rise in strong opposition to this legislation. This bill seeks to create 14-year-old prisoners in the adult criminal legal system. We know this approach doesn't improve public safety, it only traumatizes our babies. History tells us as much. Antron McCray, 15 years old. Yusef Salam, 15 years old. Raymond Santana, 14 years old. Corey Wise, 16 years old. Kevin Richardson, 14 years old. These 5 boys with big smiles and bright features ahead of them went on to experience fear and manipulation that no child should. They were threatened, harassed, coerced, abused, and tried as adults. The very harm that this Republican bill would expand. From the moment of their arrest, these teenage boys, these black boys, were treated as guilty of a horrific crime in Central Park despite being innocent of all accusations. It was part of the hyper-punitive culture that prioritized political talking points about being tough on crime and targeted black and brown communities rather than investing in resources and policies that actually keep us all safe. Sound familiar? During their trial, there was a PR campaign against the boys on TV and in newspapers. Donald J. Trump himself spent the equivalent of more than $200,000 advocating for them to get the death penalty. These 5 black and brown children were innocent, but Trump wanted them killed. To this day, he has not even apologized. And Republicans in Congress are supporting him and his bigotry with this bill. The story of the exonerated 5 is a tragedy and part of our shared history. But Republicans want it to be the future. First, their rhetoric demonized our communities. Then they began weaponizing National Guard against citizens. Now they're changing laws to incarcerate more people at an even younger age. And of course, the prison industrial complex will reap the profits. What Republicans do in D.C., they want to apply to the entire country. This Republican bill perpetuates racism. The Department of Justice statistics show that black kids are twice as likely to be incarcerated compared to white kids, despite committing at the same rate those crimes. This Republican bill is flawed. By treating children as adults, you deny them the protections from abuse from adults in prison, including bullying, physical violence, sexual assault, and rape. This Republican bill makes children's lives worse. Unlike in other states, when kids in D.C. are treated as adults, the Bureau of Prisons ships them hundreds of miles away from their family and loved ones to places like South Dakota or Texas. This makes rehabilitation harder and increases the likelihood of recidivism. But don't just take my word for it. There's a large coalition opposing this bill. Scientists tell us that young people's brains are not even fully developed until their 20s. They don't share the same culpability for their actions as adults when they are only 14 years old. Lawyers are explaining that children treated as adults, even when they are innocent, are denied age-appropriate legal protections for the rest of their lives. Sociologists finding that children who commit crimes are overwhelmingly influenced by adults and their surroundings, not their own thinking. And of course, the people of D.C. who did not vote for Trump, or any Republican for that matter, to be a city councilor. Republicans are supporting this legislation not because they care about public safety. If Republicans cared about reducing crime, they would tell Trump to stop delaying funding for community violence prevention programs that were passed with bipartisan support. If Republicans cared about victims, they would stop making cuts to the Crime Victims Fund so that people who experience harm get the help that they need. If Republicans cared about our kids, they would invest in restorative justice programs that teach children how to resolve their conflicts without violence. If Republicans cared about our kids, they would support common sense solutions to prevent school shootings. I urge my colleagues to vote no on this bill, to keep our babies safe from trauma, abuse, and fear. In the words of James Baldwin, the children are always ours, every single one. I challenge you to protect them all. I yield back.
Members are reminded to refrain from engaging in personalities toward the president. Gentleman from Kentucky.
Mr. Speaker, that's a perfect example of the difference in the two sides on how to handle crime in D.C. You have to hold people accountable for crimes, Mr. Speaker. If you don't, they will continue to commit crimes. And that's what we have here in Washington, D.C. That's why we're here today. That's why we're here today. Just coddling criminals, hiring therapists, hiring more social workers, creating more government programs. That has failed to work in Washington, D.C. and many of the cities around the United States. We have a president that's going to be tough on crime, tough on criminals. That's what the theme of this legislation is, Mr. Speaker. That's our way to reduce crime in Washington, D.C. Their way hasn't worked. We're going to do it our way if we get the support in the chamber today. I reserve the balance of my time.
Gentleman reserves the balance of his time. Gentleman from California.
Thank you, Mr. Speaker. I want to remind our Republican colleagues that crime in D.C. over the last few years has actually been going down. And quite frankly, the idea that we are now going to put middle schoolers in prison, this should be called the Middle Schoolers for Prison Act, is inhumane and shameful. We can all agree that crime should be taken on, that D.C. and other cities we want to make safer. But this idea that we're going to penalize children in middle school at the age of 14 and put them in prison is irresponsible and, quite frankly, it's un-American. I want to remind my colleagues that at this moment, what we're doing right now is stripping 700,000 residents who have come together in D.C. to create laws, to bring community together, to fight for statehood and representation. We're going to strip them from their ability to manage their own city. These efforts do nothing to reduce crime or improve public safety. And once again, I know that the president is obsessed with Washington, D.C. He's obsessed with its local laws. I ask him once again he should step down as president and run for mayor if he's so interested. Let's not put 14-year-olds in prison. And with that, I have no more speakers, and I'm prepared to close.
I'm prepared to close.
Gentleman from California.
Again, I oppose passage of this bill, and I yield back.
Gentleman yields back the balance of his time. Gentleman from Kentucky.
Thank you, Mr. Speaker. And again, we're talking about violent crimes. Violent crimes. And what we've seen in Washington, D.C. is an outbreak of juvenile crime because the definition of juvenile in this city is 7 years higher than every other city in America. And with this legislation, we're talking about addressing issues of violent crime with juveniles. And I think that, Mr. Speaker, this is the path to try to get the crime under control in Washington, D.C. I urge my colleagues to support this legislation to ensure that violent crime, including murder and first-degree sexual abuse, are taken seriously in the District of Columbia. I yield back the balance of my time.
Gentleman yields back the balance of his time. All time for debate has expired. Pursuant to House Resolution 707, the previous question is ordered on the bill as amended. The question is on engrossment and third reading of the bill. Those in favor say aye. Those opposed, no. The ayes have it. Third reading.
To lower the age at which a minor may be tried as an adult for certain criminal offenses in the District of Columbia to 14 years of age.
Question is on passage of the bill. Those in favor say aye. Those opposed, no. Opinion of the chair, the ayes have it.
Yeas and nays, please, sir.
The ayes and nays are requested. Those favoring a vote by the ayes and nays will rise. Sufficient number having arisen, the ayes and nays are ordered. Pursuant to Clause 8 of Rule 20, further proceedings on this question will be postponed. Clause 12A of Rule 1, the chair declares the House in recess, subject to call of the chair.